Tan almost everywhere. Jan almost everywhere.
They got him! We're watching The Office today, and I'm gonna react to the legal implications in Michael Scott's world.
Let's get ethical,
And talk about how it's different than the real world. Let's go.
And you were directly under her the entire time.
That's what she said.
Excuse me?
That's what she said.
Michael Scott is being deposed here. This is a great one. Jan got terminated. She's filing a wrongful termination against Dunder Mifflin Company. Now, Michael has been subpoenaed to have his deposition taken, and of course, it's hilarious.
Expect I'm in the middle of a line of questioning.
That's another funny thing here. Usually, you're not gonna have your client there instructing you on how to conduct a deposition. That's usually a bad idea.
Was nothing short of predominant.
That's what I love about Michael Scott. He tries to sound smart and he uses words that clearly he has no idea what the definition is.
Have the proof right here.
Perfect. I can see how an employer can get a little bit nervous when upper management or a person in a position of leadership starts a relationship with a subordinate. Here, Jan works in the corporate office and she's the direct superior to Michael Scott, who's a regional manager. And you can kind of see how a conflict of interest can arise. Anyways, they're saying that this is a cause of action here, potentially, that they retaliated against them because they were in a relationship together and how they had no right to do so because they apparently disclosed it to HR.
Jamaica, is that correct?
Uh-huh.
And that photograph was taken more than 2 months prior to the start of your relationship?
Perfect. So they got him in a little bit of a pickle because in that disclosure form, the date was after apparently he went on a vacation to Jamaica with her. The defense attorney is showing a picture of them together in Jamaica in, circumstances that would imply that they were a couple. That happened well before the disclosure date. So if there was this policy where it must be disclosed to HR and that date falls after they clearly got together, could cause some issues. Let's see how Michael reacts.
Mr. Scott, the timeline here is actually very important. Please, when did your relationship actually begin?
If it was from the first time we kissed sober, it was like 4 months after that.
Can we take a short break?
No, are you telling me that?
That's what I love about depositions. With a well-educated and prepared attorney, it is going to be hard for the common person that's not familiar with the law or with civil litigation to pull a fast one on an attorney. I think the things about depositions, if you're not being truthful, you better have an excellent memory because an attorney is going to ask you a question in so many different ways, and if you can't keep up, you're going to be exposed. And that clearly is apparent here, and we're gonna see this snowball into just disaster for Jan's case.
Your relationship began 2 years ago and not in February as you previously testified to here?
They got him! They got him! See, there you go. All the preparation they were doing in the car, and for who knows how long before that, out the window. Now he's flustered, and they are going to attack.
Line.
I'm sorry, what?
He asked for a line, like in a play.
See, this is where it gets really funny and ridiculous. Anybody familiar with theater and you're in rehearsals and you forget your line, you say line, and the director or somebody assisting you is gonna tell you your line. Well, he's trying to use that in a deposition. I have never had that happen in my career. Even though if somebody tries it, I will laugh so hard and I will have a great story to tell. Please try it if you're ever answering one of my questions in a deposition.
That was to get out of a question. You still have to answer it. First, can I go to the bathroom? No.
Okay, this is just a side point, not really necessarily a law on preventing you from going to the bathroom during a deposition. Whenever you need a break in a deposition, if you're being deposed, the attorney is going to ask, and this is usually clearly outlined in the beginning of a deposition, if you need a break to go to the restroom or whatever, please answer any question that is open before we take a break. So my guess here, no, it's not my guess, it actually happens. He is being asked a question he doesn't want to answer, and he's trying to get out of it by asking to go to the bathroom. They clearly know that's the reason. But you gotta be careful not to allow somebody to use the restroom, because if they have some kind of medical issue or something of that sort, they can cause you some issues. But as far as when it's clear that they're just trying to get out of questions, not the best. It's probably not going to be well received by an attorney who's deposing you. They got him. They know they got him. He knows they got him.
But I throw myself at the mercy of the deposition.
Oh, this is perfect. He throws himself at the mercy of the deposition. I have no clue what that means. As far as this endpoint here, obviously I have my beefs with how the attorneys conducted the deposition here, and of course this is all for fun. But they got him, and he knows they got him. And at that point, he decides to just be 100% truthful and forward. And he knew it ruined her case. And that's the important thing to remember about these depositions. They can make or break a case. In this particular circumstance here, she was asking for millions. And she knows her case is ruined. He knows their case is ruined. So my guess is after this deposition was over, they either settled for hardly anything or the case was just dismissed outright. But it's an important reminder that these deposition proceedings in the discovery process are so critical and can oftentimes be a reason why a case resolves early on in the litigation process.
107. I quote from
yes.
an entry dated January.
This is a
4th.
big no-no. So you do forfeit a little bit of your right to privacy. For example, if you're injured in a car accident and your neck hurts, you forfeit your right to privacy in the sense that the defense counsel can go back into your medical records and see if you had a pre-existing condition. The difference here is Michael Scott is not a party to the action. He is just a witness. So he has the right to privacy. They would not be allowed to use his diary unless he gave their permission. Another thing is, in litigation, people think that you can surprise people with evidence. Now, I can use something to impeach a deponent, and that would be the argument they would make here, is the only reason they're bringing out the diary is to impeach his credibility. But that's very problematic when you're impeaching your own witness for your own case. So anyways, that's probably never gonna really happen in a case where you depose your own witness. If you do, your case stinks.
Tan almost everywhere. Jan almost everywhere. He. More tomorrow. XOXO.
Okay.
Michael.
I'm not familiar with anybody putting XOXO in their own diary and feeling a little bit eerie. Again, Michael Scott using vocabulary, make himself seem a little bit smarter. Probably should look up the definition beforehand.
See a copy of that entire journal before we proceed.
I don't think anyone in this room has a right to read my diary.
Perfect. So you see what the plaintiff's counsel is trying to do here. Obviously, the case seems like it's all but lost for Jan. And what the plaintiff's counsel is trying to do is show that maybe Michael Scott thought they were in a relationship, but Jan did not feel the same way. And if they can somehow convince a jury that that's true, then they didn't breach HR policy, right? In order to be in a relationship, it only makes sense that both people have to consent that they're in a relationship. So this is not a bad fix that the plaintiff's counsel is trying to do here. The interesting part is it seems like they came prepared that Michael Scott was gonna do something stupid.